be providing justice. And there are a variety of examples that one could adopt, but I'm only going to take three, and I'll try to do them relatively quickly: confidentiality, appellate review, and independence of arbitrators. And in each one of these, criticisms are made sometimes of the arbitral process, sometimes in some settings, not all settings, because it's not enough like judicial proceedings. And the first, but before I look at each one of those three criticisms, let me start with my conclusion, if you will, which is that, like Joseph's story, these criticisms are all wrong. Of course, arbitration is different from judicial proceedings. That's why it's called alternative dispute resolution. If arbitration were the same as court proceedings, then you wouldn't have arbitration. Parties wouldn't agree to arbitrate, and you wouldn't have these increasing caseloads in international and domestic arbitral institutions. The appeal for the justification for arbitration is precisely because it is different, and to criticize arbitration for being different is therefore to entirely miss the point of arbitration. And by compelling arbitration to be like courts, one would indeed destroy the very reason for arbitration, as well as removing most of its appeal to private parties. Footnote: one of the reasons that the French Court of Cassation in the Prunier case in the 1840s gave for refusing to uphold arbitration agreements was, well, if we uphold arbitration agreements, lots of people might actually arbitrate. And we don't want that to happen, which I would suggest is fundamentally in contradiction to the rule of law, which guarantees the freedom of contract and party autonomy. But let's look at these three examples: confidentiality, appellate review, and independence and impartiality of decision makers. And then we can both conclude and take a few questions. It is firstly said that, well, arbitration happens behind closed doors, no doubt smoke-filled rooms where we can't really see what's going on. That's in contrast to public courts, and we will shatter confidence, public confidence in the rule of law in the state if we allow arbitration to be conducted confidentially. A few reflections on that basic proposition. Firstly, transparency is, of course, not an absolute value. Transparency is one of various values. We have other values, such as privacy and confidentiality of commercial matters, privacy of religious matters, marital matters, community matters, commercial confidences. And national courts, in fact, deal with matters of transparency in a variety of different ways. Judicial deliberations, the deliberations of a panel of the appellate court aren't conducted in most countries in public. Actually, in some countries they are, astonishingly, but in many countries they're not, because we value confidentiality in some parts of the decision-making process. In many countries, large aspects of the judicial process other than judicial deliberations are also confidential. Issues of disclosure, pleadings in some jurisdictions are confidential. And therefore there's no absolute requirement of confidentiality. Is instead one that is dealt with in many places, in many jurisdictions, in many different settings, in a nuanced manner that balances it against other interests. Conversely, arbitration also provides, in various settings, for a degree of transparency. In some settings, investor-state arbitration, arbitrations are increasingly conducted in public. It is, in fact, an interesting reality that relatively few people go to these proceedings, but for those who wish to go, investor-state proceedings are, for the most part, transparent. Not always the case, depends on the choice of contracting states to bilateral investment treaties, but states have the option to do that, and occasionally they exercise it. In some industries, arbitral awards are published and arbitral hearings are are open to other members of the community. And indeed, access of the members of the community to arbitral decisions is an important element of that form of arbitration. And so it is not, I would suggest, a sort of on-off switch. There is, in fact, a nuanced approach both in the judicial world, if you can put it that way, and the arbitral world to transparency and confidentiality, drawing different lines in different places. But, and this is really the most fundamental aspect of my commentary on the subject of confidentiality. There is a fundamental difference between litigation, which is mandatory and coercive, and arbitration, which is consensual. It is right that the state, which requires citizens to litigate in its courts, make those proceedings open and transparent to ensure that citizens who are required to attend at those proceedings and have their legal rights determined have confidence in those proceedings. It is right that the state subject itself to a certain regime of transparency. That is different from how individuals, choosing consensually how they want their disputes to be resolved, should and must be treated. Individuals may decide for very good reasons, either of privacy or out of regard for the best way to mend their relationship, that they want their disputes resolved behind closed doors and not in the full light of the press. And one can ascertain whether or not that means of dispute resolution enjoys public confidence by looking at the statistics that I referred to previously with respect to the historic and the growing popularity of arbitration. It does not detract from the public confidence, whether it's the confidence of the members of the German Shepherd Dog Association or of commercial parties otherwise, to have their disputes resolved in the manner that they wish, including confidentiality. It rather enhances their confidence in the resolution of disputes. Much the same type of analysis applies to the question of appellate review. It's sometimes suggested, well, arbitration can't really uphold the rule of law because you only have a first instance decision. It's not subject to a court of appeals and a higher court who can correct the errors that the first instance must inevitably make. And therefore, arbitration, again, is a kind of rough justice that should be treated as a second-class citizen. And again, I would suggest that this is wrong. Appellate review is not an absolute value. Appellate review is a nuanced value that is used in different ways, in different settings, in different countries. Some countries have more appellate review of different kinds than other countries. Parties are free always to waive their rights to appellate review, to not seek further review. And equally, on the side of arbitration, parties are free to structure their agreements to arbitrate to provide for a form of appellate review. And a number of arbitral institutions, the LMAA, for example, provide for internal forms of appellate review. ICSID, in the investor-state context, provides not for appellate review, but for a kind of secondary scrutiny of awards. And of course, commercial arbitral awards are always subject to the potential for annulment, with a particular focus on issues of jurisdiction and public policy. And so there are, again, it is a more nuanced picture than one system has a sort of pure form of error correction and the other does not. It's also very important to remember as well, especially in the international commercial context, that in fact the basic process of arbitration is designed to ensure expertise. The parties choose arbitrators suited to their particular dispute rather than having judges chosen at random. The parties design a procedure aimed at ensuring that their dispute is resolved as correctly as possible, including each having input into the composition of the arbitral tribunal, all of these mechanisms being efforts to ensure that decisions are better, in some sense, than otherwise would be the case. But again, most importantly, there is a difference between mandatory and coercive state jurisdiction, where it is right that the state ensure that its decisions are as correct as can be, and consensual arbitration, where parties can choose how they want the various considerations of cost, speed, and accuracy to be resolved. And that is particularly true in the international context, where appellate review in a national court necessarily injects national courts, as opposed to international tribunals, into the dispute resolution process. And just as parties are free to settle their disputes, so parties should be, and this is part of the basic premise of the New York Convention and the UNCITRAL model law, free to decide that they want arbitral decisions not subject to forms of appellate review. And that is not a reason to think that arbitration is rough justice or something that doesn't guarantee access to justice. It is simply the providing the parties with the form of justice that they believe best suited to mending their relationship. Finally, and very quickly, issues of independence and impartiality. It's sometimes said, and you saw strains of this in Justice Story's remarks, which I've quoted, that arbitrators are not versed in the law, or alternatively, that they are not really independent of the parties, and hence that this shatters public are upheld. And there is, and again, there's some degree of irony here. One of the fundamental reasons for international arbitration is to guarantee international neutrality, so that when you have a party from Hong Kong and a party from, say, Korea, the disputes are resolved by a tribunal that is not either the Hong Kong or the Korean parties' home courts, but rather an internationally neutral tribunal. And it is that which arbitration promises, and it is that which has attracted parties to arbitration. And to criticize arbitral tribunals for not being more like national courts is to simply misunderstand the basic purpose of the arbitral process. And so that brings me to the conclusion of my treatment of the implications of the right to arbitrate. It is a topic that has both, I think, a long historical lineage. We can trace it back, if not to antiquity, at least to the French Revolution. And hopefully we're in a position today to draw some conclusions from that. It is one that has been recognized, a right that has been recognized around the world, both here and elsewhere. And it is a right whose recognition requires continual continuing and continual diligence. One sees continuing doubts expressed in various ways about the arbitral process, notwithstanding its enormous popularity and the affirmations given to it by legislatures in jurisdictions around the world. And it falls on us, members of the arbitral community, and judges and legislators, to be attentive to that right, because, as I've said, it is fundamental to the access to justice and ultimately to the rule of law which stands as a guarantor of our freedoms, our rights, the right to associate, the right to contract. And attention to the rule of law requires the sort of vigorous enforcement of agreements to arbitrate that we've seen over the last 30 years, both here in Hong Kong and elsewhere. Thank you.